well, at this time, we're going to take up these, the objections during the state's closing argument. Madam Clerk, I think what we ought to do is just have them order lunch. This is going to take a while, I'm sure, and we need to give the parties a break. So let's go ahead with lunch. Okay, first of all, there was a sidebar after the close of instructions. And Mr. Nelson, why don't you go ahead and, if you would, put on the record what it is that you raised at that time.
Sure, and can I share that responsibility?
Well, if Mr. Fishney wishes to do it, that's fine.
I have just the first one, judges, on the previous, I noted on the sidebar on page 4 of the jury instructions, the first bullet point, there's the 5 words in the last line of the first bullet point, or the amount of force. And I believe that is an improper instruction on the law. There is no, at any time, analysis of anything other than her belief as opposed to the action. And so I understand Your Honor read it. We are asking that if Your Honor provides, and the state did not discuss it in their closing, we'd ask that Your Honor cross out those 5 words, edit the jury instruction. If you provide the jury, which I imagine Your Honor would.
Which 5 words? In the last sentence of that first bullet point?
Can I just approach, Judge?
I'm aware, that's fine, counsel.
Just to show you, Judge?
Yes. All right, and so what is incorrect about that?
I think it should just read, but the belief was unreasonable. There's not an analysis of whether her actions were or were not reasonable. It's about whether her beliefs about her actions were reasonable or unreasonable. And so when it says, but the belief or the amount of force used when unreasonable, that implies that a jury could say, look, we thought she had the belief, and we thought her belief was reasonable, but we thought her actions were unreasonable, and therefore it's not self-defense, and that's not the law. And so that's my concern about when we put it in there in that language. And I apologize, I missed it yesterday. I understand that, but that's our position on it.
Your Honor, I disagree that that's not the law, because unnecessary defensive force is found in 940.01 sub 2 sub B, and that reads, and I will read it verbatim, quote, death was caused because the actor believed he or she or another was in imminent danger of death or great bodily harm, and that the force used was necessary to defend the endangered person if either belief was unreasonable.
And I agree, it's all about the beliefs. My point is, I agree that's the law. And that reading of the law isn't the reading on page 4. The reading on page 4 talks about something other than beliefs when it says, but the belief or the amount of force. That's the problem. If it just said the belief about the amount of force, that'd be different. But it doesn't say about, it says or. It splices the sentence and says it has to be both about the belief as well as the action. And that's not the law. It's simply about the belief.
All right, well, I'm going to note your objection. It's preserved for the record. I'm going to keep it the way it is. I believe it's a correct statement of the law. And we disagree on that. And that is, it's going to stand.
Judge, the other thing I noted on the side was just as we were going through, I realized that there was not been a definition of great bodily harm. I'm not asking for that now. When I was already up there for the other moment, I just wanted to mention that. And then thirdly, I know Ms. Vishney wanted to comment or make record because she was involved yesterday, and I think she has some further things to say about the jury instructions. If I can hand it over.
Okay, go ahead.
First of all, on the behest of the defense team, I want to apologize to the court that I didn't catch these things yesterday, both what Mr. Nelson has caught and argued to the court, and I do agree with him. And I realize that this causes inconvenience to the court, and these are things I should have noticed yesterday, so I just want to state that. And if the court is annoyed with me, I can appreciate that. But what I had noticed during the reading of the instruction, and I do think this is a clear misstatement of the law, is on page 7 of the jury instruction. So in the beginning, in the jury instruction, the law is stated correctly that if the jury is not satisfied that the defendant is guilty of first-degree intentional homicide, the jury must consider whether or not the defendant is guilty of second-degree intentional homicide or first-degree homicide. But then when you look at page 7, under the very end where it says, make every reasonable effort to agree, and I don't have it right in front of me, or I'm about to have it right in front of me. What the jury instruction says is that it directs the jurors to consider only second-degree intentional as opposed to both first-degree and second-degree intentional. So I'm proposing.
I assume you mean first and second degree reckless, counsel?
Yeah, well, what it says is you should conclude further deliberation would not result in unanimous on the charge of first-degree intentional homicide. You should consider whether the defendant is guilty of. There I go. All right. It says, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether the defendant is guilty of second-degree intentional homicide. What it should say is, you should consider whether the defendant is guilty of second-degree intentional homicide or first-degree reckless homicide. In other words, it should parallel the language on the first page. So let me just say that I've written a potential curative here, all right? First of all, I don't think the jurors are very likely to remember the exact language, but I know that a copy of the written instructions is going to go to the jury room. So what I'm proposing you do is simply, after make every reasonable effort to agree, that the court just adds the words or first-degree reckless homicide, which would parallel page 1, and then, in fact, be a correct statement of the law. If the court thinks it's appropriate, I've drafted one more sentence, which is, you do not have to reach a verdict on one without considering the other, because that, is actually true. They can consider them contemporaneously. It's a branching instruction. So right now, the way this instruction goes, it's going first-degree intentional, down to second-degree intentional, down to first-degree reckless, down to second-degree reckless. I apologize, I don't know the names of the cases, but off the top of my head, but I know that there is definitely case law that says when the penalty structure is identical, that one charge is not a lesser included of another. I just can't remember the name of the case right now, but I know it's out there. So first-degree reckless homicide, although we might think of the state of mind as being less than intentional, because the penalty is the same, it's not a lesser included of second-degree intentional, which is what I think this jury instruction does. So if you were to just add those words, or first-degree reckless homicide, I think that would cure it, and if the court wants to add other language, you do not have to reach a verdict on one without considering the other, though that is not pattern language. So the court might feel more comfortable just using pattern language or first-degree reckless homicide. That I think would cure the problem.
Judge, I'm just pulling up the pattern instruction right now, and I want to take a look at that before I respond.
Right. I mean, I understand why the state wants to look at it, but, I think we all realize that there is a problem with this pattern instruction. It doesn't fully state the law, but it's not like we can call the jury instruction committee right this minute and get them to redo it. So I think this would cure it while still staying faithful to the way it's correctly stated in the beginning.
Well, Your Honor, the language is consistent with the pattern jury instruction. I certainly believe that the pattern jury instruction is a accurate statement of the law. I know that, they spent a lot of time looking at this. I don't agree that this is not I don't agree that this is an incorrect statement of the law. So I would just ask the court to not change it. I think it follows the pattern instruction, and I think when we start deviating from that, then that's when we start to get in more trouble than if we stick with the pattern instruction.
All right, well, I think the jury instruction committee has considerably more wisdom collectively than I do. So when in doubt, I think stick with the pattern instruction. I think it's an accurate statement of the law. I understand that first-degree reckless homicide may have the same penalty as second-degree intentional homicide, but I think this is fairly straightforward. And I'm going to leave it the way it is. So, but your objection is noted, and your suggestion is noted and preserved for the record.
Thank you. I just wanted to make it clear, I just want the court to make it clear, or I wanted the record to be clear that I have not waived this.
Absolutely.
Okay.
Absolutely.
Thank you so
Your
much,
objection
Your
is preserved. Okay. Now, getting to the arguments, Mr. Nelson, I allow you to make a record.
Judge, Ms. McCandless needs to use the restroom.
Okay.
Can the court excuse her from reviewing?
No, I think what we'll do is maybe others, would need to use the restroom as well. So I think what we'll do is we'll take a 10-minute recess. We'll come back. We'll take up the arguments related to the state's opening argument, and then we'll take a lunch break after that. Okay?
Thank you.
In anticipation that then I'll go back on at approximately 1 o'clock.
Approximately 1.
Okay.
I guess the time frame for the food would be about a half an hour, so hopefully the jury will get their food shortly after 12. And then we'll give counsel 1 hour for a lunch break. All right? Okay, we'll be in recess. Okay, there were objections during the state's closing argument. I guess we'll take them one by one. Mr. Nelson, first, when slide was put up and said one more lie in quotes. It didn't say it in quotes, but that was one more lie. There was an objection by the defense. And go ahead. What's your objection?
Yes, Judge, my objection was both to the slide as well as the use of essentially the name calling. It's one thing to say there is a lie. It's another thing to say she's a liar. And I believe they were not in the slide, but certainly in their words, calling her a liar, which I think gets to character. On page 7, of my document 122, motion in limine prosecutor's closing arguments on page 7, I think it's number 5C, we cite a case, and however, I do want to make note, Your Honor, that since then, I'm aware, Mr. Maxey has made me aware that there may be another case, State v. Miller, 2012, Wis. App 68, 341, Wisconsin 2nd, 737, which rebuts State v. Jorgensen. So it wasn't in my brief. I made the objection. I stand by my objection, but there's a perhaps case that rebuts that, so I'll just leave it at that.
All right. Mr. Dufour?
Your Honor, the law certainly allows the state to say that someone lied, even say they're a liar as long as it's based upon the evidence, and that they're lying based upon the evidence and how the evidence shows it. And I think it's perfectly acceptable argument and specifically authorized by the law.
Okay. And the court overruled the objection and based on the fact in the court's opinion that it was an argument reasonably based upon the evidence that was in the record at trial. Okay, Okay, and the next objection was, I don't have a time noted, but it was on the argument where Mr. Dufour was talking about intent as being practically certain that it would cause the death, somewhere in that neighborhood. But on that objection, again, there was a request for a sidebar that was denied. But go ahead and make your record on that, Mr. Nelson.
Your Honor, I believe the prosecutor misstated the law. His argument was whether a reasonable person would be aware, and on page 5 of the jury instructions, the meaning of intent is clearly spelled out, and it says essentially either had the mental purpose to take the life or was aware. Doesn't say should have been aware, doesn't say a reasonable person was aware, it says was aware that her conduct was practically certain to cause the death of another human being, so it was directly contrary to what the law is, and then he was making arguments about that. And so I understand that we can make arguments, but as lawyers in a court of law, I think we should be bound by making arguments that are legal.
All right, and Mr. Dufour, any record
Nothing,
in there?
Your Honor.
Okay, all right, well, the court overruled the objection, and again, when the court heard, maybe it wasn't exactly the way the instruction says, but I think using what a reasonable person would be aware of is fair argument, again, based upon the evidence in the record. Whether the defendant was actually aware or not is something that would be up to the jury to decide. And so
I understand they need to decide the facts. I'm just saying that in deciding the facts, they should be told the correct law. And they didn't tell them the correct law. He said that the law was something other than what it is.
well, all right. The jury was instructed as to what the law is. And, okay, so moving on to 1055, another objection to word. It was in argument about the journals, and Mr. Dufour used the term liar. That was objected to by the defense. And any additional record you'd like to make? I mean, again, the objections was overruled. It's preserved for the record, both by your motion in limine as well as your objection during the argument. But if you want to
No, Judge.
add to that, you can. Okay. And then also at 1111, there was an objection related to the use of the term fire in her eyes. That's, again, overruled but preserved. The objection is preserved. Your exception is preserved for the record.
Just to be clear, there was no testimony from any witness that said they observed fire in her eyes. Jason Mengel testified, and when he testified that she was fired up. And when he asked to clarify that, he said it could have been positive or it could have been negative. I know he used the word fired up. I'm paraphrasing when I'm saying could have been positive, could have been negative, but there was no testimony that there was, quote, fire in his eyes. I understand that may have been what was in the police reports. It may have been it was what the state said they were going to prove in their opening, but that's not what the proof was in the trial. And closing argument isn't about what it could have, should have, would have been. It's about what it is. And the evidence was he said she was fired up.
Well, again, your objection is
Your Honor,
preserved for the record.
And I would note, Your Honor, as far as the evidence is concerned, it's in the squad video that he states that. So while he may not have testified to that, it's in the squad video that the jury heard.
All right. Again, it's overruled, objection's preserved. And then at 1114, there was an objection about argument interpreting the physical evidence, and Mr. Nelson's objection was speculation, and overruled. But go ahead and you can complete your record on that objection as well.
I think my argument was essentially he said she stabbed him unprovoked in a rage, and there's no evidence of that. And so I just think the way that he stated it, the tone that he stated it, the matter-of-fact way, it's just complete speculation. And so that was my objection, Your Honor. There's not evidence of that in the record.
All right, well, that's, again, noted. Mr. Dufour, anything in addition you'd like to say?
Just, it's fair argument from the facts,
All right.
as far as the state's concerned.
Again, the court overruled it. The court's opinion, its argument is argument reasonably based in the evidence in the record. So I'll just leave it at that. But again, the defense objection is preserved. And I think that concludes.
I believe there was Your Honor, I can't remember the time, but I believe at some point the prosecution was speaking about Alex's journal and made comments about Alex is now here telling you that she is a liar.
Yeah, we covered that.
And I'm just,
Yeah.
I didn't know if that was one of the objections.
Yeah.
That, I made that objection for the same reason stated, and so if it was already covered, I apologize for repeating myself. I thought Your Honor was speaking of a different objection.
No, that, we did cover that one in particular, and I know you had which I have right here, your motion to eliminate related to improper arguments, but again, the court's opinion, if from the evidence, it's a fair argument from the evidence in the case, that someone lied or that they're lying or liar, if it's based upon evidence in the case, I believe that's fair game for argument in closing.
Judge, just so I make sure my record's clear.
Go ahead.
My objection was the fact that prosecution was saying Alex is calling Ezra a liar. That's what they were saying. It's not just that the prosecution was, but he says Alex is here calling her a liar. And that was the factual and legal basis for my objection, is there's no such evidence.
All right, well, again,
I'd move for a mistrial based upon that as well, Your Honor.
all right, well, that's noted. I am not going to grant your motion, but your objection is preserved for the record. I believe, again, up to this point, that the totality of the circumstances, that is not so unfairly prejudicial that it would be a basis to grant a mistrial. So that motion is denied. Okay, then we'll have a lunch break.
Judge, I know we're going to have lunch break. Normally this is closed over lunch. I don't know, can we open it like at 12:30 so I can come back and get set up, and for 30 minutes is just, I want access to the room to prepare for my closing. I think it'll just make it more smoothly more time efficient if.
All right, well, someone from the clerk of court's office will come. Okay.